Welcome to the session on legal maxims. Maxims are the established principle and proposition of law. A principle of law universally admitted as being just and consonant with reasoning. Maxims in law are somewhat like axioms in geometry. They are principles and authorities and are part of general custom or common law of the land. Legal maxims are holden for law, and all other cases that may be applied to them shall be taken for granted. The true method of its application is to ascertain how maxim arose and to consider whether the cases to which it is applied is of the same character or whether it is an exception to this apparently general rule. Most of the Latin maxims are developed in the medieval era in European countries that used Latin as their language for court and laws. So let's get started with the first maxim of the state. Nemo debat e judex in propria causa, meaning nobody can be judged in his own case. When a person has either personal, pecuniary, or an official interest in the subject matter before him, then he cannot be considered as an unbiased or a neutral person having the competency to adjudge that issue before him. It is also thus understood as rule against bias. Moving on to the next maxim, Adi Altram Partham, meaning no man shall be condemned unheard, which insists that parties to the dispute must be given a fair opportunity to be heard and to take a proper defense. The important components of the fair hearing, thus, are the notices and fair trial, to be understood as the rule of fair hearing. These are the maxims used as principles of natural justice. Proceeding further, the next maxim for the day is Q facet corallium facet per se, meaning he who acts through another acts himself. In simple words, it's a fundamental legal maxim of the law of agency. It is a maxim often stated in discussing the liability of the employer for the act of the employee in terms of vicarious, second-hand, or an indirect liability. The next maxim to follow is respondent superior, meaning let the master answer. It is related to the circumstances when an employer is liable for the act of the employee performed within the course of the employment. This rule is also called as master-servant rule. It is also discussed under the concept of vicarious liability, where a master is liable for the act done by his servant under his direction and control. As the last maxim for the day, we shall discuss obiter dictum, meaning things said by the way. It is generally used in the law to refer to an opinion or an non-necessary remark made by a judge. It does not act as a precedent. In other words, obiter dictum means that which is said in passing. An incidental statement specifically in law, it refers to the passage in a judicial opinion which is not necessary for the decision of the case before the court. But such statement lack the force of precedent, and nevertheless it is really significant. With that, we come to the end of the day's session. Today, we have discussed 5 maxims along with its meaning. We also learned the technique of understanding the same. Thank you so much for this session. In the coming weeks, we shall have the discussion on the principles of natural justice. Thank you.